particular lecture in relation to good title. Well, we are now dealing with examples of bad titles, and we try to give you some ideas about encumbrances. And in dealing with encumbrances, you must know this particular section, which was enacted rather recently, section 12A of CPO. Now, this is a section in which the Legislative Council enacted to allow certain encumbrances which could not be discharged, to be discharged, so that the piece of land or land property in question can be sold or transferred without problem. Now, subsection 1 of section 12A said, where land is subject to any encumbrances, whether immediately realizable or payable or not. Now, so whenever you look at the land search of a certain piece of land, and you find that the land is subject to, well, in most cases, a mortgage or a charge. And the encumbrancer is out of the jurisdiction, cannot be found, or is unknown. Now, why I say in most of the time is mortgage, because the second part, the encumbrancer, the one who holds this claim, is out of jurisdiction, cannot be found or unknown. You don't know who he is. Now, if for other encumbrances, for example, government notice, an order, as I said earlier, it could be one form of encumbrances, but you can always easy to identify which particular government department. It is only when it is about a mortgage, that it could happen something like that. Now, of course, I cannot rule out all the other possibility, but in most cases, my experience is there was a mortgage, even half a century ago or earlier, which is attached or registered against the title of the land. And that mostly happened in new territories land. 80 years ago, for example, the landowner of this piece of land mortgaged the land for $10, or mortgage for, say, $100. That was a really big money. And with or without interest. Sometimes the interest is money, 5% per year per annum, or sometimes it would be certain amount of rice. In one of my experience, the case I dealt with, the interest is certain catties of rice, 20斤米 each year as interest. Now, but because many new territory residents actually moved to overseas in 1960s or 1970s. They either go to, mostly they went to England first and then go to other part of Europe. You may not be able to locate the original mortgagee or any of the mortgagee's descendant, and that fits the description here. The encumbrancer is out of the jurisdiction. Well, the last known information about the mortgagee was he went to England, for example, cannot be found, or sometimes unknown, or if it is uncertain who the encumbrancer is. Now, under these these circumstances, in the past, there is really nothing the owner can do. The only thing he can do is to agree with the purchaser, saying that now, this land is subject to this mortgage, take it or leave it. But 12A now gives you one more alternative to deal with it. The court may, if it's think fit on the application of the party for the time being, entitled to redeem the encumbrances. That means the landowner is the landowner who is entitled to redeem the encumbrances. Direct or allow payment into court of a sum of money sufficient to redeem the encumbrance and end the interest thereon. Now, I have purchased a piece of land in New Territories, and the land is subject to a mortgage 50 years ago or 80 years ago. Now, I can go to court and ask the court to make an application, to ask the court to direct me to pay a sum of money enough to redeem that mortgage. Now, interesting enough, because those old mortgage, we're only talking about several tens of dollars, $50, $20, or $100. Interest, 5% per annum, 2% per annum, etc. So even if it is 100 years ago, by the time, of course we are talking the current years, you go to court, it may be just a few $1,000s that you can redeem this particular mortgage. So we'll go to court and ask the court to allow us to make that several $1,000s payment into court. And the court will then say, oh, this piece of land is now free from this mortgage. Now, this is stage one. Of course, in order to persuade the court to make that order, it is not just you or your lawyers who go to court to say, well, I want to redeem this particular mortgage. I make a computation. It is $5,699, for example. That's not enough. You have to give evidence to the court that you have tried your best to locate the encumbrancer, the mortgagee in most cases. And the usual practice would be you write to the head of that village, you write to the district officer, you post notice in that village. Say, Chen Daiman, okay, can anyone tell me who is Chen Daiman? Ask the head of the village, do you know Chen Daiman, etc., etc. And if everybody come back, we never heard of him, or the last time we heard of him was 45 years ago, for example, that kind of situation. Then you can, with this evidence, show it to the court and make that application. The court would be ready to direct you or allow you to make payment into the court, that $5,699, and make a declaration, your land is now free from that encumbrances, and an order for the director of land registration to vacate that particular registration. Okay, so this is actually step one. The second step, if it, well, we don't know whether it will happen or not, but if it really happened, would be the encumbrancer, okay, after 45 years, he actually came back to Hong Kong and wanted to get the money back and find out that his mortgage has been vacated by the court. Then this guy can go to court to apply. Of course, he has to give evidence to prove that he is the encumbrancer, or he is the so-called estate or personal representative of that encumbrancer. And if the court is satisfied with the evidence that he either is the encumbrancer or he is the, say, personal representative of encumbrancer, then the court would allow him to withdraw that sum of money, $5,699, from the bank account of the court. So is how Section 12, capital A, is to deal with this kind of unknown encompasser, whereby the encompasser was either unknown or out of the jurisdiction. So subsequent to upon payment to court of sum referred to, the court may, if it thinks fit, and either after or without any notice to the encompasser, declare the land to be free from the encumbrances, and make any order of conveyance or vesting order as appropriate. So that is after the landowner make that payment, the court then can say, makes this declaration, oh, the land is now free from the encumbrance. And this is the second step that I just briefly outlined. Or the application by the encumbrances, it should be encumbrancer, by the encumbrancer or any person entitled to have the money, the court may direct payment or transfer thereto to the person entitled to receive and give a discharge for the same, etc. And as I said, because at least my experience is that, because I deal with new territories land, the mortgage loan was usually a few tens of dollars. So by the end, even if it is 80 years ago when the mortgage was created, it could not be a huge amount of money, just a few thousand Hong Kong dollars. And even the time, which I mentioned about using the interest, using the rise as interest, we just consult the price index to find out in each year what would be the price of rice. And 20 KT of rice, then we compute a sum of money equivalent to 20 KT of rice in, say, 1945, for example. And then you have a total sum of money. And it would be still a few $1,000. That was my own experience. Now, that is the Section 12A. Now, there may be some kinds of, other kinds of encumbrances would include unregistered interest. Of course, unregistered interest would be defeated by land registration ordinance unless the interest is not registrable. If it is registrable, then the holder of that interest failed to register the interest, it would be void. But unregistrable interest would include, by contributing purchase price or mortgage installment, and forming resulting trust or constructive trust. And we have seen last time, other than Wong Chim Ying and other case about resulting trust, this is also another example in which the property was registered in the name of the woman, man and woman living together, but it was the flatmate who paid off the mortgage installment. And the court held that sufficient evidence that flatmate has acquired interest in the property. So as long as someone has made direct contribution to the purchase of the property or make contribution to the mortgage installment, they would acquire beneficial interest in the property. And this is another example. It's about a mistress. The man asked his wife to this girl to live with him, and said this is their matrimonial home. And the man said he is going to divorce his wife, but men could not be trusted. They did not divorce the wife, but the woman was foolish enough to give birth a baby for the man. But before the woman gave birth to the baby, the man actually said, well, if you take care of my baby, because at that time it's unborn, you may live in this flat as long as necessary. And the court said that there must be a contractual license for the woman to live in that flat until the baby is grown up. So, and the court said that as long as the children were receiving full-time education, this woman still can occupy that particular premises. And sometimes, if it is really exceptional, any significant improvement to the property may also allow someone to get some interest in the land. Now, remember, if it is a married couple, then this is a statutory right. If you make significant improvement to the property, you may get a higher percentage of the share of that matrimonial home. But if you are not a married couple, under normal circumstances, it is not possible for you to get any interest in the land or higher percentage of the interest in land by introducing improvement to the property, only under special circumstances, such as there was some kind of agreement between the parties. Now, if you improve my house, then you can acquire interest, something like that. So, solicitor advising purchaser should make inquiry as to the occupier's interest. Now, because remember, if those interests are not registrable, we will have to go back to equity darling. It would be a matter of whether you have notice of their interest or not. Now, if that interest holder, some unregistrable interest held by someone, and he is one of the occupier, then it would be difficult for you to argue that you do not have notice of them. If it is so one of the advice I gave to my client is to, if you want to purchase a property which is vacant. Now, if that's the case, then you may not, it's difficult to say you have notice of this unregistrable interest existing in relation to that property. If it is occupied, there are 4 or 5 persons living in this premises, and only the property is only registered in one person's name, then you should, as if you still remember, when I discussed Wang Chun-Ying, in fact, after Wang Chun-Ying, there was such a practice. The solicitor firm actually advised a client to pay a visit to the house at 12 o'clock or 11 o'clock to make sure everybody was there and ask them to sign an agreement that this property is going to be sold, so as to free themselves from such unregistrable interest. So prudent solicitors will require any occupant to make a declaration that he or she does not have any interest, or join him or her in the assignment. If that's the case, even if they have any interest, they would be assigning their interest to you as the purchaser. The third kind of encumbrances would be notice, an order from the government department. And now, remember, two elements exist in the concept of good title. One is not buying a lawsuit. And notices or order from the government may lead you to litigation, because the government is likely to enforce those orders against you. Even if you want to dispute your liability, you have to go to court. And a more notable example we include demolition order. under Section 24 of Buildings Ordinance. If you have any illegal structure on your premises, then basically the government would give you or would issue you a notice under Section 24, ask you to demolish those illegal structures. And if under the condition of sale, you may have an order to repair the slopes, for example, adjacent to your land, government is likely to issue a repairing order. Or likewise, if your property is become too old and maybe some of the structure appear to be unstable, government is also likely to issue repairing orders for you, requiring you to repair your own premises. Now, this is very important. In a multi-story building situation, such a notice or order may affect certain units. Maybe the court does, the government just issue a notice or order to flat 1A. But it does not mean that the liability is confined to the owner of flat 1A, because all owners in that multi-story building are co-owners. Such order or notice actually affects the entire building, and they could be an encompass affecting title of any unit, not just an individual unit. Now, the example is this one, Mei Heng, in which the building order under Section 27A of the Buildings Ordinance was issued. That was requiring the co-owners of that building to repair the slopes. Now, in that case, the intending purchaser of a unit, before completion, he find out that the buildings department has issued such an order to the co-owners of that building. So he refused to complete. He said this order constitutes an encumbrance on the title of the vendor. And in fact, this argument was accepted by the court, because if the owners of the flat fail to carry out the remedial work, the building authority may carry out the work and charge the owners of the work. And you don't know how much money would be incurred, particularly if you're talking about repairing some slope. And the court also noted that, as I said, there are conditions imposed on co-owners when that piece of land was actually sold to the first developer. And in fact, in that particular example, one of the conditions of sale was the landowner of that piece of land has to maintain the slope. So if the co-owners fail to do that, it may be a breach of the condition of sale, and that may invite the court to re-enter, and then you get an empty title, not just a burden, financial burden. So, if, say for example, you are representing the purchaser, and the purchaser, your client, has entered into a sale and purchase agreement with a vendor, one of the co-owner, and you find out this particular order has been issued, then actually you have two choices. Now, you have to assess what would be the possible result of that notice or order. In most cases, the co-owners have no choice but to take action. So the best thing is to get the quotation for the cost of that work. And then you make up your mind whether that amount of money would be huge enough for you to advise your client not to continue with the sale and purchase. Now, if it is not really that huge a sum of money, then one way to get that out is the purchaser may invite or the vendor, in order to prove that he has good title, the vendor may agree that, well, I'm going to bear the cost, and I will make an undertaking, to bear the cost. If it is not really a huge sum of money, the court would accept such a proposal. In fact, one of the examples is this Hui Mei Yu case. But if the sum of money was unknown, or it is likely to be a huge amount of money, then the court would be not ready to accept such an undertaking, may ease the encumbrances. Because in that particular Hui Mei case, again we are talking about a slope. The building authority under Section 27A issue a notice, an order, to require the owners to investigate the slope, and if any problem, then they have to repair. And the time of negotiating sale and purchase, the vendor failed to inform the purchaser. In fact, most vendors would do so because they know if the purchaser learn about this order, the purchaser is likely to give up. But the purchaser was able, his solicitor was able to find out the notice, and they raised a requisition in relation to this notice. And the vendor has no choice but to answer the requisition by showing the purchaser a letter from the managers of the building that this work would be at a cost of 14 million. So it is not a small amount of money. Each co-owner has to pay by a significant sum of money. But the vendor in this case undertook to bear the share of the contribution, but the purchaser refused to complete. The court held the purchaser should have been satisfied with the undertaking given by the vendor, and held that the vendor has shown good title. Now, of course, in this particular case, it really depends on which particular court, which judge is sitting to hear the case. In theory, I agreed with the purchaser's solicitor that it is not safe to complete this sale and purchase, because if we go back to the order, it was to investigate the slope and report back to the building authority. But I don't know whether the slope was stable or unstable. If it's stable, then of course 40 million would be the end of the day. But if it is not stable, then you have to spend even much more than 40 million to remedial the slope. Then the vendor's undertaking may not be that reliable. Now, but the current law on similar notice or order is that this order or notice may constitute an encumbrances only if the potential liability is such a magnitude that it would exceed anything that a reasonable purchaser would have in contemplation. That is to say, when you purchase a property, you may expect, for example, you purchase an old property, you will expect someday there may be a big repair going on. Nowadays there was, because change of law after 2003, in order to support the building sector in Hong Kong, the government required, owners of old buildings to refurbish the building. So if you are not purchasing a new property, it is likely that unless the remedial work has already been taken place, otherwise such a remedial or refurbishing work would be likely in the future. So when you purchase the property, you should bear that in mind. Now, if you think the property is really valuable in compare with the possible cost for refurbishing the building, you may be interested to purchase one of the flats. But if it is a really old building, the value of the building is low, and the potential cost for refurbish the building is high, then you may not contemplate to purchase such property. So the court laid down this rule. So if it is even if there may be a future cost to be incurred, if it is still reasonable, then such cost, as represented by notice of order, does not constitute an encumbrances of title. But if that notice of order may end up with a huge amount of money to be paid by all the co-owners, then it may constitute an encumbrances. Now, this is the leading case for this particular principle because it was decided by the Court of Final Appeal, the Cheeky Company case, Lucky Health International Enterprise. Well, the court said that because this time it's not the order or notice from government, but from a lawsuit actually, because there was an accident happened in that building. One of the workers who worked on a scaffold fell off from the scaffold and suffered severe injury, and the potential liability was very, very high. Now, in fact, you may say this is not really humane to take such a comment. Sometimes if in a personal injury situation, if the injured person died, you may end up to pay a much lesser sum of money. If he's seriously injured, for example, he become paralyzed, he could not move by himself, then the ultimate damages to be paid could be astronomical, figure, because, well, the normal way to pay compensation would include, at least, for example, this guy may need a house on the level ground. Then maybe you have to make a payment of a house for him. And then he needs a helper to take care of him. So you have to, estimate how long this guy is going to live. And then you have to pay all the fees for the helper. And then you need a car to go out. And then you have to purchase a car, and then say 10 years the car has to be repaid. Well, so at the end of the day, the ultimate sum of money could be very, very high. And in fact, that is what happened in the Cheeky Company Limited case. So the court said that whether this litigation constitute an encumbrances over title would be where the potential liability of such a magnitude that it would exceed anything that a reasonable purchaser would have in contemplation when agreeing to purchase the property. Facts of the case is about this pumper, working on a scaffold, and scaffold collapsed, and this guy sued the incorporated owners of the building for personal injuries in 1994. In 1997, now it's not really expressly mentioned in the judgment itself, but the information people leaking is that the owner knew that the decision of the court will be handed down soon, and he was afraid that it would be a huge amount of money, so he sold the property. And the purchaser, when they enter into this sale and purchase agreement, did not know the existence of this litigation. But after the agreement was made, the court entered judgment against the incorporated owners. You know, judgment is also one of the registrable interests, right, under land registration ordinance. Therefore, the lawyer representing that plumber immediately registered the judgment. And the purchaser, of course, refused to complete on learning the judgment, claiming that the judgment constitutes an encumbrances. And court of appeal in the very beginning said that the vendor had a duty to disclose to the purchaser of the pending action. The failure for him to do so was already a factor that the court would take into account, that he has failed to show good title. And the Court of Final Appeal actually upheld the decision of the Court of Appeal, because under this section 17(1)(b) of BMO, any owners of the building, but not the owner, at the time the liability was incurred. So don't think that, well, the accident happened 5 years ago. It has nothing to do with me. I am the owner now. So why should I pay? Well, unfortunately, it is you, the current owner, who has to pay. Because the liability attached to the interest in the land and pass on to the successor in title, but not the owners who held the interest of the land at the time of accident. And the Court of Final Appeal said such potential liability will constitute an encumbrances over the title when it is of such a magnitude that it would wholly outside the contemplation of a reasonable purchaser. And there are further factors that you have to pay attention to, particularly if you are a practicing lawyer, because this is defeasible. Defeasible, remember, is more serious than defective. Defeasible means that you are going to get an empty title. So what are the defeasible factors? Breach of government list or condition of sale. In the condition of sale, the government requires you to repair the slope. You did not react to the government's notice. This is a breach of condition of sale. Government may re-enter. Any breach of the terms of government list represent a risk that government may re-enter. Well, as simply as failing to pay the ground rent, the government rent, may also render the title defeasible. Breach of building ordinance, if the breaches are serious or fundamental, the title of property may be defeasible. Particularly the illegal structure, as we said, under Section 14 of Buildings Ordinance, all buildings work have to obtain approval from the building authority before commencement of work. You cannot say, oh, it would take time for the building authority to consider my building plan. Why don't I just start, my work, and by the time they give approval, my work would be close to completion, so that time would not be wasted. No, I'm sorry, because no retrospective approval is possible, and that is also why illegal or unauthorized structure present on the property are fatal to the proof of good title. And if there is a real risk that the building authority will enforce under Section 14, the title of the property is defeasible. And this case, Spark Ridge China Limited, the Court of Appeal said that the building authority as a public regulatory body has no power to agree not to enforce the building regulation. You cannot say, well, it has been at least a few years after we built this illegal structure, the building authority has not done anything. That would mean that the building authority would not take any enforcement action. Well, I'm sorry, because the court would not accept such an argument. And unless you can assure the court beyond reasonable doubt. Now, material change of user would be defeatable. If in the occupation permit, this is a domestic premises, but you convert it into industrial or commercial, then it would be without the approval of the building authority, then that would be a reason for the court to for the government to re-enter. Now, one particular example is this Willful Investment Limited case, when the original user of a shop in the ground floor of a building, the user was expressly said in the occupation permit, garage for 10 motor vehicles. So you can only use that particular shop for a garage, and at most you can only store 10 vehicles in that garage when you accept those vehicles to be fixed. But it was converted into other shops, and when one of the shops was sold, the purchaser discovered that there was a breach, material different user from the original permitted user. And the court held that the title was defective in the absence of approval of building authority. And there are other technical factors which may render a title divisible. Now remember, when we study mortgage or charge, a mortgagee cannot sell the mortgage property to himself. Now, if you are purchasing from an owner who was originally the mortgagee, but he get this property by purchasing the property when he himself sold the property in the name of mortgagee, then the title would be divisible, because the court would not allow the mortgagee to sell the property for himself, to himself. And the possible divisible factor would be the improper execution of individual document. Now, you must have the authority to sign, meaning to execute a deed. Now, if you are a human being, no problem. You can just sign without any difficulty, and it would be not against the law. The most complicated situation, well, of course, now this has been solved. The problem now has been solved by a new enactment of Section 23A. But in the before, say, I can't remember exactly which year that new law was passed. But in the past, in any event, many people like to hold the real property by a company. Okay? Now, when the company sell the property, they need to put on the assignment, particularly, because a deed needs to be signed, sealed, and delivered. Okay? Now, I don't know whether you are aware of this or not. A company in Hong Kong, registered in Hong Kong, would have a steel seal. It is not the company chalk. It's not the chalk I'm talking about. It is a steel steel one, and it was impressed on a piece of paper, then you have the company's logo, name on the piece of paper. Now, you must use that particular steel seal to execute a deed. And if you remember your law in your business organization, business association, I'm sorry, you should know that, you know, the authority of the company is to be executed by the directors, in most cases, the directors. And those authorities is reflected in the memorandum of association. And in most cases, execution of a deed has to be attested by 2 directors of the company. But if people in Hong Kong using a company to hold a property, in many cases, in fact, there is only one shareholder, one effective shareholder. And this guy will also be the sole director. So when he attests on this use of the steel seal, it is contrary to their own memorandum of association or articles of association, so that such seal, use of seal, is not authorized. Now, if that's the case, the assignment by that director, one single director, would be ineffective, and therefore there was no assignment. The property still belong to the company, and the title you get would be defeatable. But the recent enactment of Section 23A of CPO has solved many of such problems, because under this particular section, the law said that if it appears from the document itself there was no problem, then purchaser would not be allowed to say, because there was only one director executing the assignment to use the seal, the title was not good. So, and there are other examples of possible defects, such as the name of the assigner appear to be different from the owner of an assignment. And when the assignment was executed, the power of attorney, but the power of attorney has expired when that document was executed. These are also defeasible factors that if you're representing a purchaser, you should be able to detect all these factors before you approve that the vendor has shown good title. And a prudent solicitor representing the purchaser himself would make a search in the land registry of the property to ensure that all the title document has been given to him. You know, if there is any documents given to you which do not match the description of the registration in the land registry, you should always raise a requisition. So, solicitor representing purchaser have to examine carefully each and every document and raise requisition on all such potential defects. And of course, they also have to observe the time limit in raising requisition. And as I said, nowadays the usual time frame would be 7 working days after the title document were passed on to the solicitor of the purchaser. And in terms of formulating speculation. Again, we have a set of law dealing with raising requisition, and we do not have to know in detail about those laws. But basically, you can only ask question in relation to the title only, and you have to formulate your requisition, formulate your question precisely. If you make some speculative requisition, or you're asking something which is very broad, then the vendor solicitor may not be required to answer your requisition. And if you make a valid requisition, but the vendor solicitor did not answer it, set it to your satisfaction, you should insist on repeating your requisition. Otherwise, it could be seen as you have abandoned or waived the requisition. And of course, on the other side, the vendor solicitor has to answer all the requisitions satisfactorily. And this is, in fact, an important part of the vendor's duty to show good title. And because in this active kins case, the court said that even if the vendor actually has a good title, the vendor would still have to be failing to show good title if he could not satisfactorily answer a requisition. And if that's the case, the purchaser can rescind the sale and purchase agreement. And so the vendor has to answer the requisition with candor, but the vendor has no duty to answer unnecessary, frivolous, and vexatious requisition. But sometimes, of course, two different solicitors may have different views, and parties may end up in a vendor solicitor summon under Section 12 of CPO in relation to some question and answer of requisitions. Now, what about if a vendor finds that he could not answer some requisition? Now, in the past, it would mean that the vendor is in breach of contract and he would be liable to all loss suffered by the purchaser. But about, I would say, 15 years ago or some around that period of time, solicitor has developed a new practice. So it is now common in Hong Kong that a particular clause is inserted in the formal agreement to allow the vendor to rescind the agreement if he is unable or unwilling to deal with a requisition. But of course, this particular clause must be expressly provided in the formal sale and purchase agreement. The court would not imply it into the agreement. Now, so if you are representing the purchaser, you detect a defect in the title, but the vendor fails to give you a satisfactory answer. You have to assess what would be the consequences of accepting this particular defect. Of course, it is up to you to advise the purchaser such possible consequence, whether the purchaser should accept, or should give up the property. But as I said, many Hong Kong purchasers would choose to accept. But it is your duty to advise him about all the possible risk. And sometimes you may require the purchaser to sign a statement saying that you have already advised him about certain risk, but this purchaser still want to complete. Now, that would protect solicitors when this purchaser in future try to sell the property but was rejected by the subsequent purchaser for the same defect that you have already detected. So from time to time, the solicitor would require the purchaser to sign certain document to relieve his possible burden. Now, of course, if the defect is some minor matters or can be remedial, then the purchaser solicitor should require the vendor to cure the defect. And sometimes, even time is of the essence, purchasers may allow the vendor to take more time to deal with the defect and then postpone the completion date. And sometimes if you are not sure, then you may advise the vendor or purchaser to go for a vendor purchaser summon for the court to determine the nature of the defect. Now, if all purchasers' requisitions are all satisfactory answer, we come to the stage of giving good title, And now under Section 13A, it would mean that the vendor has to produce all the original copy of the title deeds. And if anything is missing, vendor must provide a clear and cogent proof of, the three elements required under Wing Kun: contents of the missing document, its due execution, and the fact that it's lost or destruction. And of course, when you're representing the purchaser, when the vendor said, "I only have certified copies," you have to be very, very careful, because the vendor may be committing some fraud upon the purchaser. Now, if in the recent year, in the last year or so, you have been paying attention to the news report about fraud in sale and purchase, you will understand what I'm saying. People may pretend to be the vendor, the owner of certain property. They would just manufacture a forged ID, pretended to be, Chen Diamond was the owner, pretended to be Chen Diamond, but the photo was that guy. So, in one of the cases, even the court said that ID was so well forged, even professional could not tell. They have to be examined by a real expert using, microscope and all things to find out the ID was actually forged. And there are also forged copies. And I dealt with a case in which the entire building, was sold by someone who was trusted by the owner. The owner was a Japanese couple. They trust a woman supposed to be the kailoi of the Japanese couple. And this woman was so, how should I describe? So bold to sell the entire building in Tsim Sha Tsui, by using certified true copies. Now, this is an example I gave you. The vendor was a developer of small houses in new territories, and the developer agrees to sell a small house to the plaintiff. And in the conveyance of small houses, the purchaser solicitor, of course, you still remember the law, would require the vendor to produce 3 certificates of exemption and a no objection letter from the district land office. Now, the no objection letter is equivalent to our occupation permit in other land. But in the small house situation, they would not have occupation permit. They would have what we call no objection letter from the district land office. saying that the government has no objection, the owner to occupy this small house. And the vendor produced the certificate and a copy of the letter of no objection. After completion, the purchaser discovered that all the certificates and letters of all objection were forged documents. Now, of course, this time it was the developer who is selling the property. You can still locate him. But if it is only a single individual, I bet by the time you discover those documents being forged, that guy has been absconded. And this time, the purchaser took out an action to rescind the agreement based upon fraudulent misrepresentation. And the court held that fraudulent misrepresentation make out, and the purchaser was entitled to rescind the agreement. Even if there is no issue on title, either the purchaser and vendor is entitled to rescind the sale and purchase agreement for breach of conditions of the agreement. It's a matter of contract law. Breach of condition would allow the innocent party to terminate the contract. For example, time is of the essence. If you fail to complete on time, then it would be a reason for the other party to terminate the contract. Now, even the condition of deliver vacant possession, it could be cause you problem, you know. And in fact, in a very rather recent case, we are talking about plaintiff agreed to purchase a building of 20 units, so not just single unit, but 20 units. And in the formal sale and purchase agreement, the vendor agreed to deliver vacant possession. But after completion, plaintiff inspect the property, but they find the rubbish, debris, chattels inside 3 units was substantial, and defendant demanded defendant to clear them before completion. But defendant refused to do. He said, "Well, I sell you the property. These are not the property were not occupied, so it is vacant possession." But the court disagreed. The court agreed with the purchaser. Those debris in the 3 unit was so substantial that the court did not agree. The vendor has delivered vacant possession, and that would interfere substantially or prevent the plaintiff from enjoying the right of possession, and the plaintiff was entitled to rescind the contract in that case. So there are many, many interesting things in sale and purchase of properties in Hong Kong. If you are really looking, well, of course, in most cases it was very straightforward. But once you have an interesting case, it was really something that would make you very, very much enjoy dealing with such sale and purchase conditions. Okay, so that's all about the encumbrances or good title. Now, perhaps I think most of you should be here already, so we can look at the assignment. look at part 1 first. Now, I hope all of you have the assignment with you, because it seems that this visualizer is not that good. Okay, part 1. Stephen owns a 2-story building called Good Hope Center in Taipei. He also runs a drinking internet bar called iBar at the ground floor of Good Hope. He enters into the following arrangements. Number 1, Stephen agrees in writing with Patrick, allowing Patrick to run a local snacks kiosk in the iBar entrance lobby without charge for 3 years, or any time iBar is closed down, whichever is shorter. Patrick, however, has to pay the cleaning fees for the kiosk. In order to provide the cleaning services, the agreement also provides that Stephen is to retain a key to the kiosk, so that Stephen's cleaners at the iBar can also clean the kiosk daily. Number 2, Stephen allows Wallace, who runs a computer shop at the ground floor of the building next door, to use the advertising hoardings on the roof of Good Hope, as long as Wallace wished for no charges. But Wallace has to arrange with independent contractors and pay for the repairs and maintenance of the hoardings. Number 3, Stephen orally agrees with Janet to let the first floor of Good Hope for her to run a yoga and Zen meditation center at a monthly rent of $15,000 for 4 years. Janet has spent $300,000 in the refurbishment of the floor to convert the same into a venue suitable for yoga and meditation exercise. 3 months later, Stephen sells the entire Good Hope to Peter. Peter wants to demolish Good Hope and redevelop it into a high-rise building. Advise Peter. Okay, so we have a number of agreements entered between Stephen and others. But after these agreements has been executed, Stephen sold the property, the entire building, to Peter, and Peter wants to demolish the building. So in order to demolish the building, of course, he has to terminate all such agreement. Otherwise, how can he demolish the building? So what you want to advise Peter is whether these agreements are binding on him, so that he could not kick out Patrick, Wallace, or Janet. If they can stay, then of course Peter cannot demolish the building immediately. They have to wait until the agreement expires. So, under what circumstances that Peter cannot terminate the agreement? Because the agreements were entered into by Stephen with the other parties. Under the doctrine of privity of contract, Patrick should not be bound by any of them, because he is not a party. So, under what circumstances that Peter would be bound by this agreement? So look, for example, look at the agreement between Stephen and Patrick. Under what circumstances that Patrick can insist to stay until, the end of 3 years. Now, if it is simply a contract, then of course Peter would not be bound by it. But if it is in the case of Stephen and Patrick, if it is a tenancy, if it is a lease, then it would confer a proprietary right on Patrick, right? If that's the case, Patrick can enforce the agreement against Peter, even though Peter is not the party who execute this agreement, because he got this proprietary right. So we have to see whether this agreement between Stephen and Patrick should be a lease or tenancy agreement, or simply a contractual license. Because if it is a lease, then it will confer proprietary right on Patrick. If it is only a contractual license, then it is just a contract, right? So, what are the definitions for a lease? Street and Mumford said there are 3 elements for a lease, right? What are those? Fixed term, exclusive possession, and rent, right? Now, look at the agreement here, and also section 5 of CPO said that if you want to create an agreement in relation to land, it must be in writing and signed by the parties. Now, we have Stephen agrees in writing, so that satisfies the requirement of CPO, section 5, section 3 or 5. But is there a term? 3 years. No, there is a term, fixed term. What about any time I bar is closed, whichever is shorter? If it is definitely 3 years, of course, there's a fixed term. But we have a variation. Any time I bar is closed down, whichever is shorter. So if I bar is closed down more than 3 years, then the list, or at least this particular agreement between Stephen and Patrick would have ended at 3 years, because whichever is shorter. But IBA could be closed down within 3 years. But we don't know which particular day bar would be closed down. So under that circumstances, we may say there is no fixed term. So you'll have to deal with this particular part to make your judgment whether there is a fixed term in this particular agreement between Stephen and Patrick. Number two, for free or without charge. So no rent. Is that fatal to a lease? Schmidt and Mumford said 3 elements, but later on we have another court of appeal case which said rent is not essential as long as you have fixed term and exclusive possession. That will do. So without charge may not be fatal to this agreement in terms of the agreement, whether this agreement is a lease or license. But what about exclusive possession? Now, Patrick has to pay cleaning fee for the kiosk. And in order to provide cleaning services, the agreement also provides that Stephen is to retain a key to the kiosk. Now, possession of the key by the landlord would be an indicator that the so-called occupier is not a tenant. He has no exclusive possession because the landlord can always enter, with the key. But what is the reason for Stephen to retain the key here? Is to allow the cleaners to enter the kiosk to clean, and Patrick has to pay for such cleaning fees. So you have to analyze whether this particular arrangement would amount to exclusive possession or not. So you have to decide whether in this particular case, 3 years or any time I-bar is closed down would satisfy the requirement of fixed term. And, without charges, I already indicate that this is not really important, but you have to cite that English Court of Appeal case to support your argument that, without charge would not be fatal to a lease. But then you have to analyze this particular part, whether the key kept by Stephen to allow the cleaners to enter the kiosk for cleaning would defeat the argument that Patrick has exclusive possession. Now, if you can, now, you really do not have to say whether it is a lease or license, but you have to analyze each of these 3 elements in this particular arrangement and give your opinion. You may say, based upon my analysis, is it more likely to be a lease or it is more likely to be a license? You don't have to say it is definitely a lease or definitely a license, because in exam or assignment questions, the examiner deliberately makes things ambiguous. And in fact, that is the fact of life, and that's why people has to go to court to ask the judge to decide sometimes. If everything is so clear-cut, then there's no need for any lawyer to have litigation in court. So for this particular section, it is easy to deal with the without charge, but you have to deal with whether there is a fixed term or whether Patrick has exclusive possession of the kiosk. If it is a lease, of course, Peter could not demolish the building until 3 years. Now, the second part, Stephen allows Wallace who runs a computer shop at the ground floor of the building next door. So it is another piece of land. Whenever there is 2 pieces of land, what should pop up in your mind? Easement, yeah. It's possible an easement. So you have to look at the characteristic here. Now, Wallace could use the advertising hoardings on the roof of Good Hope. So it could be, the roof could be the Servian tenement, and the computer shop at the ground floor would be the dominant tenement if an easement exists. So you look at what the nature of the easement, it should accommodate the dominant tenement advertising hoardings. Remember the case about the outer wall, yeah, using for advertisement for the public house next door. The court said that this should be an easement because it enhances the value of the public house, no matter who is the owner. So this is a case that you have to make use of in dealing with this second part. Now, Wallace have to arrange independent contractor to pay for the repairs and maintenance of the hoardings. Now, one of the characteristics for easement is that the owner of the Servian tenement is not required to incur expenses for the easement unless there are two exceptions. But apparently those two exceptions do not apply here. So asking Wallace to deal with the repairs and maintenance of the hoarding appear to be reasonable and would not make the this particular arrangement defeating the purposes of easement. Again, if there is an easement, then Wallace may stop Peter from demolishing the building. Stephen orally agrees with Janet to let the first floor of Good Hope for her to run a yoga and Zen meditation center at monthly rent for 4 years. Now, can a list be created orally? Yes, but it must be satisfying the free requirement, not exceeding 3 years, market rent without a premium, right? 4 years. So immediately it brings this oral agreement out from valid tenancy agreement. But Janet has spent $300,000 in the refurbishment of the floor. Could Janet said she has a proprietary estoppel to stop Stephen from denying his right, her right, even though this contract, this agreement is not a valid list, but at least she would have this right to occupy the first floor, at least for 4 years, to use it as the yoga and Zen meditation center, by reason that relying on this oral agreement, she spent $300,000 for the refurbishment. So basically, these are the issues that you have to deal with in relation to this three. Now, of course, when you advise me at the conclusion, you would say something like that. Well, should any of them, Steve, should Jenny got the proprietary estoppel, or Wallace get an easement, or the first character is Patrick got a list, then Peter could not do anything until either the 3-year 4 years pass, you know. But if all of them are simply licensed or contractual license, that would be another issue, because Peter is not party to the contract. He can always make use of his proprietary right as the owner to take those Persians away. He will not be bound by any contractual license. Okay? Now the second part, Romeo and Juliet. So Romeo White and Juliet Black in a tour in Prague met each other in a tour in Prague. And they have a romantic good time together. When they came back to Hong Kong, Romeo purchased a flat in Kowloon. Although Romeo paid the entire purchase price, the title of the flat was assigned to both of them as registered owner, holding the property as joint tenant. Just look at this particular paragraph. What would be the possible legal problem? Romeo paid the entire price, but the flat was assigned to both of them. So there are two possibilities. One, Romeo is the sole beneficial owner, whereas Romeo and Juliet are the registered owner holding the property on trust for the benefit of Romeo. Resulting trust, that is. You know, I purchased property in another's name. I'm holding the property on resulting trust. Another possibility, well, this guy fall in love with the girl, so it may be a gift, right? If it is a gift, then even if it was Romeo who paid the entire price, both Romeo and Juliet may be at the same time registered owner holding the property on as joint tenant, and they are also beneficial owner holding the property as joint tenant. Okay, 1 year later, Romeo purchased a small house in Typo to live with Juliet and their daughter Mary. The small house was bought in the sole name of Romeo, who paid a 10% deposit, and the balance of the purchase price was raised by way of a legal charge with Kowloon Bank. The mortgage installment was paid by automatic transfer from Romeo's Kowloon Bank account. Romeo worked as an accountant in White and Little and was the only breadwinner of the family. Juliet stayed at home to look after Mary. Before Mary was born, Juliet used to be a successful interior designer. She has carried out extensive home improvement so that the value of their small house has significantly increased. So look at this paragraph. So we have again to look at the ownership of this small house. Now, who paid the purchase price? Romeo paid the deposit as well as, you know, the mortgage installment. So apparently he's the only one who contribute to the purchase price. But Juliet carried out extensive home improvement so that the value of the small house has significantly increased. Now, under normal circumstances, extensive home improvement would not give Juliet any beneficial interest if they are married. But apparently there was no evidence here they have married, but at least you have to mention that. If they have married, then under Section 9 of matrimonial and property ordinance, you can look at the slide. Then the party who improves significantly the home would acquire a higher, certain beneficial interest in the property. So again, apparently, Romeo is the registered owner because it registered in his own name, the sole name of Romeo, and he is also the beneficial owner because he's the one who paid the deposit as well as mortgage installment. The question is, what Juliet has done to improve the home would have give her some beneficial interest. And apparently they give birth to a daughter and they live together, whether there would be any common intention between them that Juliet would get some interest in the property. Now, another year later, Romeo left Hong Kong without notifying Juliet. Soon after Romeo left, Kowloon Bank served a solicitor letter on Juliet and informed her that Kowloon Bank had exercised its charge's power of sale and sold the house to Robert Little, Romeo's partner in White and Little. Juliet was asked to move out of the house within 1 month. Juliet wants to know her right in relation to the flat and small house. So in relation to the flat, it goes back to the first paragraph, about whether it is a gift, or at least from Romeo to Juliet, or Juliet remains to be the trustee when her name was used as the registered owner. And in relation to this small house, again, we feel that apparently it would be Romeo's own house. He registered in his own name, make payment, mortgage installment, all by him. But what about this particular extensive home improvement? Could it be, number one, showing a common intention that this house is going to be owned by them, so that Juliet improved the house? Number two, whether they have registered as married couple. In that case, the improvement may make Juliet acquire certain beneficial interest. Now, the house is sold by Kowloon Bank to Mr. Little. Now, in relation to this small house, because Juliet's name is not registered as one of the owner, then of course, whether her interest in this farm would be binding on the bank or on Mr. Little would depend on whether she has registered her interest. But would this be registrable interest only when the interest is created by deed or document that they are registrable interest? But it is obviously not. And when it is not registrable interest, we go back to the equity darling, whether relevant party would have notice, right? With notice of the existing of the right of Juliet. Now, who is Little? Little is the other partner in White and Little. Could you at least ask whether Little knows that Romeo is living with Juliet in a small house, etc., etc.? Would he have noticed of the interest of Juliet? in particular, if they actually get married, then Julia's right also would be protected by, her being the wife of Romeo, and the house was their matrimonial home. So basically, these are the issues that you have to deal with in relation to this second part. It's about co-ownership. The first one is about lease and easement. Part 1, Part 2 is about co-ownership. Any questions?
How many works?
2,000 words for both. So about 1,000 words for each part. Of course, if you think I need more words for first part, for example, I'm not saying that you really need that. Say you should not make a huge difference between the number of words. Say 1,500 words for the first part and 500 for the second part. Then I'm sure that you are getting something wrong. If there may be some difference. Maybe you will spend 1,000, at most 200 for one part and 800 words for the other part. That is, I think, the limit. If you have to use more words, like 1,300 words for one particular part, think twice. You must have thinking too much for that particular part. So 1,000 for each part, or 1,100 for one part, 900 or so for the other part. I think more or less like this. Okay? Okay, let's take a 15 minutes break. And maybe this evening we can get home earlier, because the last lecture was a short one.